Thank you. This is a wonderful panel. And my question is directed at Jonathan. Thomas Jefferson had a proposal that a constitution should be rearranged every 20 years or so, each new generation. That each generation should have a convention and create its own constitution. And Madison, if I remember correctly, has a response to that. Could you explain that response and why Madison believes that it is not wise to simply throw out your fundamental constitution as the years go by?
Yeah, no, that's a great question. The response is a bit complicated, actually. So Jefferson's principle, right, is the earth belongs to the living. He believes that a past generation does not have the right to govern the current generation any more than one nation has the right to govern another. And Madison actually is quite sympathetic to that principle. In fact, he cites it later on in his career to justify the proposition that you don't have a right to run up a huge national debt that you're imposing on your children and grandchildren for them to pay. On the other hand, Madison sees massive practical problems, prudential problems, with putting that into radical practice, because ultimately I think he's more attuned than Jefferson to the fact that governance is dangerous, that it can very easily be abused, and that when a society manages to set up good institutions that promote the legitimate ends of governance well, that's something to be treasured. That's not actually just something that the past is binding us with, but it's also, if you will, a gift that the past is giving to the present. So Madison still believes that the society has to presently consent to those laws, but he's willing, in the case of institutions that have been explicitly consented to by one generation, to say as long as a later generation doesn't explicitly revoke that consent, they can be understood to be tacitly consenting to them. A great question.
Next question.
My question is a little bit more specific, and specifically, to quote Dr. Crenshaw, quoting Mayhew, or paraphrasing him anyway, the end of government is human felicity and not misery. This kind of pulls in the concept of the balance of powers, but specifically the property tax issue, which is a big issue in Florida right now. And our governor has been talking about eliminating, because it does cause misery for a lot of people, and certainly there is no happiness without a home, and many people are being forced out of their homes because they can no longer afford the property taxes, which to me seems to be a problem with the local governments abusing their power and raising property taxes off the charts to a point where it's no longer possible for a lot of people to pay their property taxes. So I'm just wondering what your thoughts are, any of you actually, because it does involve the balance of power and also the ends of government being human felicity. How do we reconcile the abuse of power at the local or state level with respect to property taxes and people actually having the opportunity to be happy, to stay in their homes, to be secure?
Yeah, that's a great question. I'm not as familiar with the situation here in Florida, but there's two comments here that I'll make, and they're kind of two extremes. One extreme is you go to Amdani in New York and say, well, everybody's got to be happy, and so government's going to seize all property or distribute wealth or whatever. Like, you could use the felicity of the people as an excuse to do great trouble. On the other hand, you could have just kind of a very strict and procedural enforcement of a kind of legal regime in which you say, well, this individual has the right to do this, or this company has the right, the state has a right to collect property taxes in order to fund itself and so forth. And so instead of considering the effect, the kind of aggregate effect of individual siloed laws, which in themselves may be technically okay, instead of considering the effect on the happiness of the people, you get too narrow and procedural in your administration of government. So you should, like in this case, I think you should consider like owning a home, being able to raise your family and a home and a land that you own, all of the virtues that come from owning property. Like we talked about, you know, in Massachusetts, being a property owner brings about a kind of investment into your community such that it gives you permanence here. You're not just passing through, you have an investment in, you know, this community being well governed, having good citizens. And so like you want citizens to own a home. That's a virtue, and it's part of the quote unquote American dream. So I do think that like as legislatures think about like changing tax law, they should consider things like people who don't own a home and who are, you know, having to live in sky high rents in an apartment or something like that. This does lead to misery and societal unhappiness. And what you will eventually have is a backlash of a younger generation that turns to a more socialist type mayor or somebody, or governor, who will give them what they want, be it by taking it from others. So,
if I can chime in from a Madisonian perspective, kind of in parallel and maybe complementary to that, from a Madisonian perspective, you run into a bit of a tension, I guess, between authority simply considered and authority more complexly considered, because it's like Ben said, at a direct level, right, the founders pretty uniformly are going to say if your constitution allows the state to collect a property tax, then it has the right to collect a property tax. And Madison specifically is going to say at the societal level, you've certainly given control over that aspect of your life to the society, and as long as it's imposing it equally, it has the right to do that. On the other hand, you do also get into questions like, if this is done in such a way that it's actually making the individuals in the society as a whole worse off, that's bad. But then Madison's immediately going to raise the question, but then why is the society doing that to itself, which goes to the second limit that I mentioned. If it de facto is one part of the society kind of levying taxes on another part of the society, that might run into a more fundamental problem in terms of the authority to do things like that. I'm not sure if that's helpful, but I hope so.
And I'd add just that it illustrates, I think, something about why these questions are so difficult, and why although the founders spoke 250 years ago on these things, we're still debating what they were meant by what they said, right? Because, I mean, at a high level of generality, right, we can all agree that the end of government is the happiness of the people, but then immediately you get, okay, what does that mean, right? And it's, you know, is a property tax or certain taxes at a certain point they become so onerous that yes, they do become incompatible with the happiness and welfare of the people. But obviously, if you're not collecting any taxes at all, then just give the most obvious example: public schools are funded by property taxes, and this state and most others. And obviously, there is providing for the education of children is important. Now, there are other ways of doing it. And another example would be, at the founding era, property taxes were a fairly standard way of collecting taxes, and through a lot of American history, because it's very easy, right? Administratively, you know what people's where their house is, and you know approximately what it's worth. Whereas something like income, except for the Civil War, there were no income taxes in America until the 20th century or the mid 20th century or early 20th century, and that obviously there's all kinds of administrative elements to that were simply unavailable earlier. And so what that raises, of course, is that all these questions are in a sense prudential as well, right? There are principles such as consent and of the governed, which is limited by prudential consent. Well, how often can we get people's consent, right? And so I guess the one way I have thinking about this is that that kind of political principles are indeterminate because human language is indeterminate, right? 2 + 2 is 4. Anyone who can understand that will agree with that, right? But when you get into political principles, inevitably there is ambiguity and room for disagreement, which is why we are having the conversation continues.
We have time for one more question.
Thank you. As we discuss federalism and the relationship between the federal government and state governments, what's the point of the state constitution repeating protections that are already mentioned in the U.S. Constitution? Does it not become redundant, or why do we have that extra step there?
Excellent question. From a sort of Madisonian authority perspective, the answer is that protections in the constitutions do several things. Perhaps the most directly important of which is when a society grants power to its government. Oftentimes it wants to say, especially in the case of the states, go do pretty much anything that's going to protect the rights and advance the well-being of the society. It's a fairly general mandate that's standard at the state level. But then wants to say, okay, but there are certain areas where we don't trust you. And so we're going to pull that authority back over those areas. So one of the reasons to have similar rights protected at the federal level and at the states is simply because they're different societies pulling back authority from different governments. So if the state of Florida wants to give its government most authority to govern, but wants to say, okay, you can't use general warrants. I don't know the Florida state constitution. It could say, okay, but one of the restrictions on that authority is the state government may not use those general warrants. And then the American people can also say to the federal government, same deal. You have authority to administer criminal law, but you can't do this. So part of the reason is just you're restricting different governments. Part of the reason might also be, from a Madisonian perspective, one of the important things that bills of rights do is codify or like hold up for reverence particular principles. And in different eras, different governments are going to be more kind of in your face. People are going to be more familiar with them. I think today, probably most people are familiar with the US protections, especially the First Amendment, not so much with their states. In the founding era, I suspect that was reversed, so that the state constitutions might have been more familiar with protections of principle.
And I'd add to that, and this is a kind of something that gets overlooked a lot today, but that at the founding era, or at least as it was, or at least it was later interpreted by the Supreme Court, the Federal Bill of Rights did not apply to the states. And so this is part of the older Federalist conception, is that the states and the national government had very different responsibilities. And so certain rights that you would guarantee, in particular phrasing that you might apply to the federal government, you just wouldn't do to the states. So there's a real way in which, like, when you say that Congress shall make no law respecting the establishment of religion, right? Well, there were state-established religions, right? And you wouldn't have said that you would just simply make no law whatsoever in this area, because they're basically saying Congress just is not involved here. Whereas there's an idea that there's certain balances between the public welfare and individual rights. That balance and how you think about it and how you conceptualize it and how you protect it could look different state to state than it would at the federal level. So yeah, and that's something that changes in the late 19th century as for one thing, as the Bill of Rights is incorporated against the states through the 14th Amendment through the Supreme Court. But it's also, I think, people now tend to see the federal and state governments as kind of doing similar things, and they do a lot of similar things. Like, it's not like the federal government today is totally uninvolved in education and things like that, or even at the state level. They're both kind of, they have different responsibilities, but they're very overlapping. Whereas at the founding era in the early republic, these are very different governments in many ways. Their responsibilities are different. Their spheres of authority are different.
Join us in falling in love with America again.